All right, this is in the matter of Teresa Osburn versus ITF Tile Company and Joseph Totu Frank, file number 21-6644CK. We have Ariel Berger, P83695, appearing on behalf of the plaintiff, and Martin Lozier, P47775, appearing on behalf of the defendant. And we have Mr. Lucas, and you are not lurking. You are here on to observe on behalf of whom?
JBS Design Services, who has been named as a additional defendant, I believe, on an amended complaint that was filed by Ms. Berger recently.
All right, very good. So we are here on defendant's motion for summary disposition. This was scheduled at 8 o'clock. I had some pickups this morning. It is now 8:27. So Mr. Lozier, this is your motion.
Thank you, Your Honor. One housekeeping issue. The improper venue portion of my summary disposition motion should have been made pursuant to MCR 2.221 and not MCR 2.116C1. So I would like to make that correction for the record. And I would also request, for purposes of this court adjudicating my motion for summary disposition here today, Your Honor, and based on the plaintiff recently found an amended complaint adding JBS Design Services LLC, who is based out of Hillsdale County, that the issue of forum nonconvenience is waived by my clients for the time being, but I want the overall objection, Your Honor, preserved for the record pursuant to MCR 2.221A if an answer to the amended complaint is required to be filed by my clients by this court.
Okay, very good.
Okay. So if that has been noted for the record, I'd like to proceed with my motion for summary disposition for oral argument. So, Your Honor, count one for the breach of contract complaint. Plaintiff failed to plead any of the legal requirements in order to have a valid enforceable contract. You need offer, you need acceptance, you need consideration, you need mutuality of agreement, mutuality of obligation. A meeting of the minds is required. And in the case of oral contracts, which were pled, the burden is raised to a clear convincing standard.
I'm sorry, I couldn't hear that. Oral contract, which were pled?
Which were pled in oral case or oral contract, the burden is raised to a clear and convincing standard. None of these critical components were pled. The reason being they don't exist, Your Honor. Pleading number 2 does state that the plaintiffs understood the relationship between the parties and stating that defendant Totu Frank often works as an independent contractor with the designer. Cutting to the chase here, Your Honor, it is obvious and verified from the documents, the evidence, and the affidavit provided by defendants Joseph here as to what happened in this fact pattern. Plaintiff contracted with JBS Design Services to perform interior design work for her home. One of the agreed upon services to be provided by JBS was to install tile and a hickory wood hardwood floor. JBS thereafter purchased the necessary tile and hickory wood floor to have it there on site. JBS, being Jenna Salabine, lacked the expertise to install the flooring, so she goes out and hires and retains a subcontractor to perform the work. That labor and expertise was provided by my client, Mr. Joseph Totu Frank, who completed the work required fully. Accordingly, that is why in the end, JBS billed the plaintiff directly the entire project amount of $35,988.24 and was paid directly by the plaintiff the full entire amount. My client, Mr. Frank, who had a contract with JBS in turn to provide the labor for the install, and that is it, billed JBS $7676.25, and that's pursuant to my Exhibit 3 attached to my motion for summary disposition, that he was immediately paid by JBS for the work completed. In summary, there is no contract relationship between the plaintiff and the defendant. Defendants Joseph are entitled to summary disposition pursuant to MCR 2.116C5 against the plaintiff herein because the plaintiff does not have standing to sue my client. The plaintiff in this case is not who my client entered into a contract with. The party plaintiff entered into a contract with was JBS Services LLC. In addition, pursuant to MCR 2.116C8, Based on the plaintiff's pleadings filed, the complaint fails to state a claim. Now, I apologize, Your Honor. I failed to include the standards for MCR 2.116C8 and 10 in the brief, so I'm going to state them right now. Motions brought under MCR 2.116C8, as this court is well aware, are decided on the pleadings alone. No other evidence may be considered. When deciding a motion under MCR 2.116C8, the court must accept as true all factual allegations of the complaint. Such a motion should be granted in the circumstances under which a complaint fails to state a claim, despite the court taking all factual allegations as true, where the defendant owes a duty to the plaintiff as a matter of law. Consequently, I'm stating taking those pleadings as fact alone clearly state that there is no claim against my client with regard to this matter. With regard to MCR 2.116C10, those motions are based that there is no genuine issue of material fact, and the moving party is entitled to judgment as a matter of law. A party seeking summary disposition under this subpart is required specifically to identify those issues about which the party believes there are no disputed material facts and must submit affidavits, depositions, evidence, and other documents in support of the motion. When faced with a properly supported motion under MCR 2.116C10, an opposing party may not rest on mere allegations or denials in its pleadings, but must by affidavit or other document or evidence set forth specific facts showing that there is a genuine issue for trial. My point with regard to MCR 2.116C10 is also a dismissal because there is, in fact, no disputed fact or issue as to the relationship between the parties. It is what it is. The evidence submitted by the plaintiff actually as attached as part of their report, their inspection report, shows that there was an estimate and an invoice generated from the plaintiffs. This documents were submitted, Your Honor, that show that those bills were paid directly by JBS or by the plaintiff to JBS. In addition, I want the court to know that plaintiff has not filed a response to this motion for summary disposition. She only filed an amended complaint. MCR 2.116G4 states, when a motion under subrule C10 is made and support is provided in this rule, an adverse party may not rest upon mere allegations or denials of his or her pleadings, but must by affidavits or as otherwise provided in this rule, set forth specific facts showing that there is a genuine trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. Specifically states that in MCR 2.116G4. Further, Your Honor, there's a question based on plaintiff failing to answer the motion for summary disposition. Is she allowed to even amend her complaint before the summary disposition motion is to be heard? Defendant asserts the answer is no, but if the court requests me to proceed regarding arguing the amended complaint, I will proceed. Would you want me to argue on the motion summary, Your Honor, based on the amendment or stick with the original complaint?
On the amended.
Okay. So the amended complaint, defendants Joseph are aware that as a result of my motion for summary defendants Josephs are aware that as a result of my motion for summary disposition filed, plaintiff reacted and immediately filed an amended complaint to attempt to fix the numerous defects in her original complaint filed. The amendment was filed pursuant to MCR 2.118A. The amendment, in my mind, Your Honor, represents a clear admission of guilt by plaintiff's counsel that the original complaint filed pursuant to the new MCR 1.109 was not well-grounded in facts or warranted by existing law. Plaintiff has now included JSB Design Services LLC as a party, as Mr. Lucas has pointed out, as a party defendant, and dropped Mr. Joseph Frank Tutu individually from the lawsuit, and now additionally dropped the count 4 titled capacity. In addition, the court should be aware plaintiff incorrectly named the defendant JSB Design Services LLC, when in fact the correct name is JBS Design Services, and that's confirmed in the LARA website from Licensing and Regulatory Affairs. Setting aside that small issue, the amendment now additionally excludes pleading number 2, wherein plaintiff stated Mr. Frank often works as an independent contractor with the designer and inserts in his place plaintiff is unsure of the type of professional relationship that exists between the defendants in this matter, and as such just named both defendants. My problem with that is, so if all else fails, figure it out. So if all else fails, let's name them all and let the judge figure out who should be in and who should be out. I find it hard to believe that counsel for the plaintiff cannot figure out or fails to understand who her client retained to perform the interior design work she had completed. All you need to ask is basically, who did you meet with? What was agreed upon? Who was invoiced? Did you meet and have a written agreement? And who did you pay? Nevertheless, the amended complaint, in a similar fashion to the original complaint filed, fails miserably, except for the adding and deleting of the parties, removing the count title capacity, and the wording is described above inserted. It's the same fatal mistakes that were previously existed. There is one pleading that I do want to comment to the court that was added referencing MCL 600.1405. That's pleading number 9, where plaintiff states plaintiff is a third party beneficiary of any agreements between the defendants. Third party beneficiary law, Your Honor, specifically under this area of the law, which is incidental third party beneficiaries in construction contracts, is a completely different area of the law requiring detailed specific fact pleading. It states that subcontractors, being Mr. Frank Tutu, are generally held not to be third-party beneficiaries of the contract between the general contractor and the project owner. And even if the plaintiff asserts there is some form of third-party beneficiary rights, it requires very specific detailed fact pleadings, which plaintiff is not provided in the amended complaint. And even if she did, the claim would fail in accordance with Michigan law. For the same reasons listed in the original complaint, Your Honor, I'm requesting plaintiff defendants move for summary disposition pursuant to MCR 2.116C5, 8, and 10. With regard to count 2 for unjust enrichment, equitable doctrines recognize when a party has been unjustly enriched at the expense of another. In order to sustain a claim of quantum merit or unjust enrichment, the plaintiff must establish the receipt of a benefit by the defendant from the plaintiff and an inequity resulted to the plaintiff because of the retention of the benefit by the defendant. In other words, the law will imply a contract to prevent unjust enrichment only if the defendant has been unjustly enriched or inequitably enriched at the plaintiff's expense. So for an example of this, Your Honor, where I've seen it customarily occur is in account balance lawsuits. Party A requests Party B to make him 50 widgets at $100 a widget. The work is completed and Party A receives and sells the manufactured widgets, but refuses to pay Party B for whatever reason. Say he's robbing Peter to pay Paul and he has to pay some other creditor. Not only does Party B now have a breach of contract claim against Party A, but also an equitable claim for unjust enrichment. Party A has effectively been unjustly enriched in receiving the manufactured widgets that he sold at the expense of Party B, who performed the manufacturing work and was not paid for the work completed. That is not the type of case or fact pattern presented in the case before us. The law will imply a contract to prevent unjust enrichment only if my clients, Joseph and ITF Tile Company, have been unjustly or inequitably enriched at the plaintiff's expense. Plaintiff Ms. Osburn in pleadings number 6 and 15 admitted that the defendants fully installed the flooring. Furthermore, defendant Frank states in his affidavit, pursuant to his invoice generated, he was paid by Jenna Salabine from JBS after a complete inspection was performed by both the plaintiff, Ms. Osburn, and Jenna Salabine on behalf of JBS for the install work completed. In order for the plaintiff to have a proper claim for unjust enrichment, plaintiff would have to plead that defendants Joseph and Tile Company, ITF, received the full payment from JBS without performing any of the installation work required. That is not the case. Defendant Joseph performed the entire work and completed the installation of both the tile and hardwood floor completely approved with payment made after inspection was performed. I am requesting dismissal pursuant to MCR 2.116C8 and 10 for the reasons stated above. Unjust enrichment, the pleadings fail to state a claim for relief, and there is no genuine issue of material fact for a claim for unjust enrichment, either in the original complaint or the amended complaint. It does not exist. Count 3 for fraudulent misrepresentation. Your Honor, the requirements to prove common law fraud are 6 of them. The defendant made a representation of mere material fact, and the representation was false when it was made, and the defendant knew it was false when it was made or made it recklessly without knowledge of its truth, and the defendant made the representation with the intention of inducing the plaintiff's reliance, and the plaintiff acted on reliance upon it, and the plaintiff was damaged as a result. Fraud must be pled with detailed particularity pursuant to MCR 2.112B1. The complaint must specifically identify the time and place of misrepresentation, describe them as misleading statements or facts. They must be material, and describe the benefits the defendant wrongfully obtained as a result of the misrepresentation. My point, Your Honor, at no time ever did the defendants, Joseph or ITF Tile, ever contract with the plaintiff, either in writing or orally. JBS ordered and completed delivery of the tile and the hickory wood hardwood floor as in past jobs for JBS. Defendant Joseph then shows up and completes the installation of the tile woodwork floor without incident or discussion with the plaintiff. All the work was completed in 3 days, starting from April 7th through the 10th of 2018, was inspected thereafter by both the plaintiff and JBS, with JBS subsequently paying the defendants Joseph on April 20th, 10 days later, the amount of $7,676.25. So all this information is confirmed in defendant Joseph's affidavit attached to our motion, which is Exhibit 2. Accordingly, if defendant has the critical issue here, accordingly, if the defendant has no verbal contact with the plaintiff, other than showing up and completing the work, how can there be any fraudulent misrepresentation? Plaintiff's original complaint consisted of two pleadings alleging common law fraud. First, that the defendants represented to plaintiff that would provide hardwood flooring pursuant to the parties' agreement, and two, that in reliance upon the representation, plaintiff furnished $34,427.24 for the flooring to be installed in her home. First, the hardwood flooring was provided by JBS, not defendant Joseph, who just provided the labor for the installation. The pleadings make no sense and provide no information regarding any representations made by defendant Joseph, let alone ones that were fraudulent. Plaintiff's claim for fraudulent misrepresentation must additionally be dismissed. It should be also noted plaintiff's amended complaint replicated or copycatted my recitation of the common law requirements for proving common law fraud. Those were all included, obviously, in my summary disposition on this matter, and specifically plaintiff pled new counts 19 through 21 regarding defendant Joseph making repairs to the mistakes in the flooring. Somehow, even if that was true, and it is not, defendant Joseph was there completing some additional final tile work unrelated to the wood flooring problem, and that was 6 months later in October after the initial work was completed. The amended pleadings fail to show how completing this additional work results in any form of common law fraud or misrepresentation occurring by the defendant Joseph against the plaintiff. Accordingly, the defendants Joseph and ITF request dismissal pursuant to MCR 2.116C8 and 10. The pleadings alone are completely deficient in pleading any form of fraud, Your Honor, and there's no genuine issue of material fact, either in the original or amended complaint, that would create a legal claim of fraud against defendants Joseph and ITF Tile. Count 4 for capacity. Plaintiff attempted in this confusing count to somehow differentiate the defendants in an individual corporate capacity and performing installation work as an independent contractor. In my answer, in my motion for summary disposition, defendant Joseph has a valid state of Michigan residential builder's license in full force and effect in good standing. That was included as an exhibit to my motion. Once this information was included as a summary disposition filing, included in our motion filing, the plaintiffs have now dropped this count from the amended complaint and removed defendant Joseph individually from the lawsuit. This is another example, Judge, of a clear admission of guilt, I think, by the plaintiff's counsel that the original complaint filed pursuant to MCR 1.109 was not well-grounded in facts or warranted by existing law. In fact, I don't know what account for capacity under Michigan law means, but neither here nor there, apparently under the amended complaints, it's dismissed. So as a result, we request dismissal of this capacity count pursuant to MCR 2.116C8 and 10. This will appropriately segue, Your Honor, my presentation that if all counts of the complaint are dismissed as requested in this summary disposition motion, I am also requesting this most honorable court award my client actual attorney fees pursuant to MCR 2.625A2 as a frivolous action as defined in MCL 600.2591. The court is aware, pursuant to 600.2591, frivolous means that at least one of the three following conditions is met. The primary purpose in initiating the action or asserting the defense was to harass, embarrass, or injure the prevailing party. The party had no reasonable basis to believe that the facts underlying that party's legal position were in fact true, and the party's legal position was devoid of arguable legal merit. After reviewing all the information, I have concluded all three of the frivolous definitions are met in this case. Specifically, plaintiff knew from her pleading number 2 that defendant Joseph was a subcontractor hired by the general contractor JBS to perform the install. That was the understanding of the relationship, as was confirmed in plaintiff's pleading number 17, when plaintiff stated defendant has been unjustly enriched in the amount of $86.76 paid to him in labor costs. Plaintiff even included as part of her complaint copies of both estimates and the invoices that reflect that plaintiff paid JBS direct for all the work completed. Plaintiff with certainty had to logically know and conclude that the party she had a contract was in fact JBS and not the defendants Joseph and ITF. In addition, Your Honor, I have to tell you I was surprised and somewhat shocked that plaintiff chose to file an amended complaint and not file an answer to this summary disposition motion. The amended complaint, as I previously stated, clearly represents an admission against interest or guilt by the plaintiff that the original complaint filed pursuant to MCR 1.109 was not well grounded in facts or warranted by existing law. The amendment now dropped my client individually as a party defendant, eliminated the count title capacity, which made no sense to begin with, and attempted to copycat all my summary disposition motion brief and case research in dropping and adding pleadings to try and salvage her case. Although plaintiff is allowed, Your Honor, to amend her complaint pursuant to MCR 2.118A, the decision to not answer the summary disposition motion is fatal pursuant to MCR 2.116G4, and frankly is effectively, in my mind, turning a blind eye to court rules and stating, I don't need to answer the motion for summary disposition. I will file an amended complaint and the court will accept it and figure out who is in and who is out. That's not how it works. And finally, on a side note, the cost of litigation, Your Honor, is extremely expensive. My client is spending thousands of dollars with me in meetings, preparing the motion, briefing it, researching it, filing it, and arguing it today. This litigation process is not a training ground for attorneys to figure out how to plead an appropriate case. And I don't mean to be disparaging to opposing counsel, but I also need to point out to this court, when in deciding if award for actual attorney is appropriate, please take all this into consideration. I think it is appropriate. As a matter of fact, I know for a fact it is appropriate in this case that I be awarded my actual attorney fees. Plaintiff's complaint filed or as amended was not well grounded in legal facts or warranted by existing law and was completely devoid of any arguable legal merit as required by MCL 600.2591. For all the reasons stated above, I am requesting the full dismissal of this case with prejudice against defendants Joseph and ITF, and further requesting an award of my actual attorney fees pursuant to MCL 2.625A2 in conjunction with MCL 600.2591. In having to defend this frivolous action, I will also request the court schedule an evidentiary hearing for the appropriate amount of attorney fees and costs to be awarded by this court. Now, I do want to make a comment, Your Honor, with regard to agency law, because there were some comments made with regard to plaintiff's case about referencing in agents. And there is no agency relationship here. There are independent contractors. JBS is the general contractor. It's clear from all the evidence and information submitted, and my client is a subcontractor to JBS Design Services. That is confirmed based on, number one, evidence supplied by defendants Joseph, specifically the plaintiff's estimates and invoices billed. Two, the amounts paid by plaintiff to JBS direct and only to JBS, which is Exhibit 1 to my motion. Defendant Joseph's affidavit, Exhibit 2, confirming the general contractor-subcontractor relationship. Exhibit 3, defendant Joseph's invoice billing directly to JBS. Number 5, plaintiff's amended complaint, pleading number 4, where she admitted her contract was with the newly named JBS Design Services, LLC. And number 6, the plaintiff pursuant to MCR 2.116G4 failed to respond to the summary disposition motion, acknowledging effectively there is no genuine issue of material fact for trial, resulting in no agency relationship between the Yosef and the newly named JBS Design Services LLC. That's all I have, Your Honor. Thank you very much for my presentation.
All right, Mr. Lucas, could I inquire, you're potentially going to be appearing on behalf of JBS Design, is that correct?
Correct, Your Honor.
I was a little distracted by the fact that it's in Hillsdale County, but Jenna Salenbein is related to Linda and Dan Salenbein, is that correct?
I don't know, Your Honor.
I believe she is. And Linda Salenbein is a friend and former employee of mine. So I do believe she is. And if she's going to be added to this, I do feel that I'm going to have a conflict.
Understood, Your Honor. I completely understand. I just don't know the relationship. I just met Miss Salenbein. Actually, she was referred to my office, Your Honor. Maybe this might help to clarify it. She was referred to my office by Angie Borders. So.
Yep. Give me 1 second. I'm going to take a recess real quick.
Thank you.
Thank you.